And today we are going to have two sessions. So the session one, we are going to look at dispute resolution and negotiation. And session two, we are going to look at intellectual properties. So in dispute resolution and negotiation, we are going to look at common business disputes, contractual, employment, and partnership. We are going to look at negotiation techniques for resolving disputes, and we are going to look at mediation, arbitration, and litigation process. This is your host, Dr. Tulipo Mwenfumbo. Remember, this training or this workshop is coming from the book entitled Business Law, written by Dr. Tulipo Mwenfumbo. And if you want a copy of this book, you can WhatsApp me on +260 976 1812 53. +260 976 1812 53. This program is brought to you by UNAP EduTech. The mission of UNAP is to make education accessible, available, and affordable for all. UNAP EduTech is an online campus for universities and colleges. So you can do any of our programs at PhD, Masters, Bachelor's, Diploma, and certificates. We offer certificates, mostly which comes as a workshop. Let's dive into our today's course. So we are going to start with looking at common business disputes. What are the common business disputes? First, when we look at the disputes, we are talking about the disagreements in businesses. So where you don't agree with your partner or the employee or your client. So now, how do you resolve such disputes legally, or how do you resolve such disputes as a business person? So the common business disputes are: number one, contractual disputes. These are disagreements over contract terms, performance, or breach. So there is what is called contractual disputes, where you disagree with your client on terms of contracts, performance, and breach. For example, you give your client to do something, then he does it weirdly. So that is a breach, and you may disagree on that. So the other example that I can give on contractual disputes, these are the non-payment or delivery delays, breach of terms. So where people have not delivered what you agreed on, or they have delayed the the delivery, or they have breached the terms in the contract. What causes contractual disputes? Contractual disputes are caused by miscommunication, unclear terms, and unforeseen circumstances or unforeseen changes. There are some times where you get into a contract, then you discover that there were some things that were remaining. So that may cause what is called breach of contract. So now, if you don't communicate effectively in the contract that you are doing, it may be a breach, or it may cause some disputes. So disputes are caused when there is miscommunication, when the terms of contract are not clear, and also when there are unforeseen changes that comes about in the contract. So you begin to dispute: no, we are not going to pay you. No, you have to pay us. I've completed the work. No, you have not completed the work. There was this and this and this. So those are the reasons for contractual disputes. Then there is also what is called employment disputes. These are conflicts between the employers and the employees regarding wages, benefits, or working conditions. So the workers, the misunderstanding or the disputes between the worker and the employer, that is what is called employment disputes. Now, these conflicts can come between the employers and the employees. and the major cause may be maybe on the wages. Maybe you are paying less, or the workers feel they are being paid less, or benefits or working conditions. Maybe the working conditions is there is no safety in that working conditions, and also other conditions that the employees feels they are not satisfied by what they are offering to the employer. Examples of uh, employment disputes. Number one, unfair dismissal can create what is called employment disputes. Then also discrimination, where you are, if the worker feels is being discriminated, that can also cause what is called disputes or wage disputes. So these are the things that causes the disputes. Now, the causes are what are the causes? Number one, misunderstandings. Most of the disputes comes from misunderstanding, where somebody is looking in this way and another one is looking it in this way. They may be talking about the same. Like I heard the story where the couple differed because one was talking about the rat, the other one was talking about the mouse. Then they started, no, this is a rat, this is a mouse, this is the rat, this is the mouse. They fought and they divorced because they did not understand. There were misunderstandings there. It is not because this one knew what he was talking about or the other. It is because the perception and the names they knew that particular animal, they did not they do not agree. They were misunderstanding. Then policy variation. So when there is variation of policy, then performance issues, where the employer feels the employee is not performing as expected. There are disputes that comes about in such a case. Then the other type of dispute is the partnership disputes. This is a disagreement among business partners regarding decision making, profit sharing, or exit strategies. The partnership disputes is caused when the partners they are differing on issues, maybe of profit sharing. This one is saying, no, I have to get the right share because I had to put in this. And this one said, no, we never agreed about that. We have to agree on 50-50. Then, or sometimes it is on in decision making. And other time it's exit strategies. So examples, as we have said, it may be profit sharing, decision making, exit strategies. Causes of partnership disputes. Number one, misaligned goals. You know, when two people or more come together, each one has got a perspective. So this one is looking at it in this way, and the other one is looking at it in this way. So that creates the disputes. And also it is mostly caused by lack of communication and also financial disagreement. And financial disagreement and also misaligned goals are the major challenges when it comes to disputes among the partners. Negotiation techniques and resolving disputes. Now, as a business person, as an employer, or as a consultant, you should learn the key principles in handling disputes. The first thing that you have to do, if you are the one affected or you are representing your clients, the first thing that you have to do is to prepare, understand the interest, goals, and alternatives, which is called best alternative to a negotiated agreement. So now this is whereby you need to understand what is the cause of the dispute, what is the interest of the other party. What are they trying to negotiate on? So you have to look at that. Then communicate, listen actively, focus on interest, not position. You have to focus on interest. I statements must be avoided. So you have to look at what is the focus. What are we trying to resolve? If, for example, you are, it is on the issue of profit sharing with your partner, then you have to lay down what is really the challenge. Okay, what are you? Why are you saying what you are saying? The other person has to explain, has to say it. Then problem solving, explore options to flexible, aim for win-to-win situation or outcomes. So in dispute resolution, always you need to be able to give in so that also your partner or the other party can be also give in something. So the other thing is build rapport, establish trust, stay calm, be respectful. When there is a dispute, it is very much important to build rapport and to establish trust. You need to trust your partner or the person, the other party in the dispute, and also you have to create and build trust so that they may trust you. Stay calm. Don't be sarcastic. Be calm. Listen to them. Reflect on what they are saying and be respectful. Now, there are what is called the steps in negotiation. Number one, prepare, gather facts and set objectives. What really do you want to achieve by that negotiation? Number two, you need to discuss, open dialogue, clarify interests. Number three, you need to propose, suggest solutions and bargain. The reason why I'm saying that I have to get this amount because I have invested so much and you invested so much. Don't you think that it will be unfair when there is difference in investment but we share the same profit? When say no, we cannot do that. Okay, why can't we just remove 10%? Your 10% be added unto me. So you are bargaining. Then agree, document terms and finalize. So you have to document what you have agreed on. Now let's look at mediation, arbitration, and litigation process. What is mediation? Mediation is a neutral third party facilitating a discussion to reach a mature, acceptable agreement. So this is a situation whereby the other party who is neutral comes up with a decision or comes to help in the agreement so that both parties will be satisfied. So the process is that there must be a neutral third party who should facilitate the discussion, non-binding outcomes. Negotiation, you just talk one-to-one, but on mediation, there must be the third party. Now, the pros and the cons. The pros are that flexible, confidential, preserves relationships. So you need to be flexible. And as the mediator, you have to be confidential and you have to preserve relationship. So as the whole purpose, when you differ in business, know that there are other parts of life where you agree on. So relationship has to be preserved. The cause, as the mediator, you should not enforce decision. Arbitration. Arbitration is a neutral third party makes a binding decision after hearing evidence from both. So the difference between mediation and arbitration. Arbitration is that mediation, you don't make decision. You just help people to negotiate and to come up with the decision. But in arbitration, that's when you can say, no, this is how it should be. And the decision should go in this way. That is arbitration. So the process is the neutral pair third party makes a binding decision. The plus is that this is faster than litigation, private. So you go maybe like to the labor office when it comes to labor or employment disputes. Now, the labor officer who is going to make the what is going to make a decision. Say, now, after hearing from this, I think the employer, you need to do this to the employees. So that is arbitration. So in that way, you are able to get the result fast. Then the cons are that less formal than court, limited appeal options. So in the arbitration, you can, if you are not satisfied by the decision of the arbitrator, you need to go to court. There is nothing like appeal. You just have to sue again. The case has just to start from zero. Litigation. Litigation happens in the court. A court of law makes a binding decision after hearing evidence from both parties. And the court has got power to enforce the judgment. So court proceedings, judge makes a decision. The pros is that the court enforces judgment. If the judgment is enforceable, follows strict rules. The cons are costly. Taking the case into court, it is costly, time consuming, and also it may affect the relationship. Key consideration when there is any disputes in business: number one, you need to preserve relationships. Your focus should be preservation of relationship. Consider the impact of dispute resolution, ongoing business relationship. As I said, sometimes you may have the challenge in one way, but there are other many things that you can agree on. Cost and time. You have to consider cost and time. Cost is time. Money. Time is money, and also the cost involved. You are in business. You are there to make money. You are not there to spend money. So evaluate the cost and time required for different dispute resolution process. You imagine you have got the case which is someone is owing you, maybe let's say this person is owing you $100. Then you decide to go to court. You'd find that the costs that you're going to pay are more than just accepting that money has been lost. Control and flexibility. Consider the level of control and flexibility offered by different dispute resolution process. So the best practices when you are dealing with disputes, you need, number one, communicate effectively. Clear and respectful communication can help prevent disputes. So consider every pro and con when you are doing the contract, either with employees or with your clients or with your partners. Document everything. Keep accurate records of agreements, communications, and transactions, so that when the dispute arises, you are just going to refer to the document that you agreed on. Seek professional advice. Consult with lawyers, mediators, or arbitrators as needed. So by understanding common disputes, negotiation techniques, and dispute resolution process, Business can effectively manage conflicts and protect their interests. So you need to choose the right method based on the dispute's nature. Negotiation, mediation for relationships, arbitration, litigation for binding outcomes. So you need to look at what is going to favor you as a business person. Thank you so much. Remember to get the book entitled Business Law, written by Dr. Tulipo Mwanfumbo. And this program was brought to you by UNAP EduTech. UNAP is an education platform where you can be able to get a degree, a diploma, a certificate in any of the field that they are, which is available. Thank you so much and God bless you. Let's make it in the next session. Today we are having two sessions. So we are going to have the next session where we are going to look at session 2, where we will look at intellectual property and dispute and business ethics. Intellectual property and business ethics. And that is the session that we are going to cross with in this workshop. Thank you so much and God bless you. Shalom, shalom.